Welcome, everyone. I think there's a disproportionate number of people on this side compared to here, but we're happy to have Dr. Shallow Magno with us today. And let me just read from her bio sketch. Dr. Magno was a former finance undersecretary for fiscal policy and monitoring, where she also chaired the Philippine Extractive Industries Transparency Initiative, the Fiscal Incentives Review Board, and the Interagency Investment Promotion Coordination Committee Technical Committee. Her name is synonymous with championing anti-corruption initiatives, transparency, and accountability in and outside of government. She also sat on the board of various civil society organizations. In 2024, she was selected to represent civil society in the Global Steering Committee of the Open Government Partnership, and she currently serves as the co-chair of the steering committee with the government of Spain. Dr. Magno has more than 20 years of experience 20 years of experience. So you started when you were 5 years old? Okay. 20 years of experience in research and policy work with the public and private sector, including local and international agencies. Her research and interest focuses on public finance, law, health, institutional and resource economics, and industry regulation. Her publications include discussions on health, pharmaceutical competition and access to medicine, corruption, foreign investments, decentralization and local public finance, energy and mining, economic and social development, and the court system, to name a few. So she will be discussing her latest paper examining judicial assertiveness in the Philippine Supreme Court. So let us all welcome Dr. Shallow Magno.
Instead of that very long introduction, if you Google my name, it says that I'm a vlogger. So I don't know what's harder, to become a associate professor or to become a vlogger. Well, today I'm going to discuss about judicial assertiveness of the Philippine Supreme Court. It's actually a collaboration with Professor Gatmaitan. You can tell which part of the study was done by Professor Gatmaitan and which part was done by me. So what we did is actually look at mega political cases from 1990 to 2023. We encoded mega political cases. You can ask him later to explain what we mean by mega political cases. But we also built on an existing study by Professor Bjorn of Australian National University, and Attorney Christina Bonoan, who I think will be attending today. They had an initial study, and then we built on the database that they are using. Okay, so of course, the first question that we have to ask is, why do we have to study the Supreme Court? And the Constitution, our Constitution, it recognizes the delegation of power between the different branches of government. But also, what is important is that in situations or in contexts where we see, for example, democratic backsliding, people normally rely to the court to protect this principle. So it's very important to ensure that courts are reliable in terms of how they formulate policies, how they interpret policies. Because similarly, if legislation produces policies, courts' interpretation of legislation also becomes policy. Okay. From an economic perspective, of course, courts play a very important role. It's the enforcer of the rule of law, which in economic sense protects property and the enforcing of contracts. And of course, a very strong relationship between an independent judiciary and individual liberty, economic growth, efficient firms, greater access to market credits and investment. So it's in our interest to make sure that the judiciary functions independently. But what do we really observe? Okay? In reality, and this is not just in the Philippines, in many countries, it's actually a field of study, judicial politics. And what we are seeing is there are various theories explaining how members of the courts interpret policy. So you have the formalist perspective, you have the activist court, etc., etc. In some court system, you can see gender playing a role in terms of how courts make decisions. So in that case, it's very important to look at the different theories that have been established in terms of analyzing court behavior. So one theory that has been tested is the loyalty effect. What does that mean? It means that when justices are appointed, the tendency is to be loyal, to make decision that favors the administration that appointed them. Okay, and so even in the United States, that has been observed, and it's more obvious. The evidence is more obvious when looking at Democratic judges versus Republicans. But in general, you can see justices in the US Supreme Court more likely to vote in favor of government, especially with the president who appointed them. Okay. And then another theory is the strategic defection. What does that mean? So when justices observe that government is about to end its term, so nagwi-wane na yung influence niya, then the justices are more likely to decide against the government. So nagde-defect na sila. Mas nagiging stronger na yung kanilang prinsipyo. They just have more guts in terms of deciding against the existing government. So that's what you call strategic defection. Then we have the freshman effect. So when you're a newly appointed justice, the tendency also is to vote with the majority and to favor the person that appointed you. So very similar with the loyalty effect. Okay, the other thing that we can derive from this theory is that the longer you stay in the court, then the more likely that this justice becomes more confident in terms of voting against the administration. Okay. The fourth theory that's out there is the judicial assertiveness. It means that the court is more capable of challenging powerful actors. It also suggests that the court is swayable. It's sensitive to how their decisions will be perceived by the different political actors. Okay, so this is very interesting, especially for people who are using the court to influence policy. When you go to court, you can look at the profile of the justices, and just by looking at these theories, you can make a prediction on how individual justices will make how they will interpret the current laws with respect to the case in question. Okay? So for the existing literature in the Philippines, there are three main studies, one by Dressel, Inoue, and Bonoan, 2023. Two other papers are, of course, authored by Professor Laarni Escresa in 2013 and 2012. The three studies observed loyalty effect in our Supreme Court decisions. Okay, so meaning our justices, based on the data that have been examined, have the tendency to be very loyal on the presidents that appointed them, especially in cases that favors the administration. And then Dressel Bjorn Dressel, that's Professor Bjorn Dressel, in 2023 also observed the freshman effect in their study. And then two studies, Dressel in 2023 and Escresa in 2013, also observed strategic defection, but very weak. Okay, so for purposes of our study, what we want to examine is whether the court is capable of doing judicial assertiveness. Okay, or are they really sensitive to the political strength, the political support of the various branches of government. So kung mas popular, halimbawa, the president has very strong public support, will that have an effect on how Supreme Court will decide on a case that covers the rights of this administration? So that's what we're trying to do here. Okay? So before, some studies assumed that political clout just automatically wane over time. So pagkatapos na yung term ng presidente, they assume that there's less political clout. What we did is to replace that assumption of by using the variables of SWS, the Net Satisfaction Survey, because as we've seen in the Duterte administration, it's not really true that the popularity of the presidents waned by the end of his term. So maybe it's an outlier, but we want to see how it will affect the decisions of the court. Okay, so for purposes of research question for this study, are the Supreme Court justices' decisions affected by the decrease in popularity or the popularity of the other branches of government, specifically the executive, the House of Representatives, the Senate, and its own popularity? And then we also, of course, checked whether we can still observe strategic defection, the freshman effect, and the loyalty effect. So we also tested for that. With respect to the data set, as I said, we used the existing data set of Professor Bjorn Dressel. Their studies from 1986 to 2022, they looked at 70 cases. What we did is expanded it to include cases in 2023. But our problem is that the data was becoming skewed because there are a lot of mega political cases that was decided in 2023. So we had to go back and start reviewing the data set from 1986 to be able to balance the number of cases across presidential terms. Okay, so the second data that we included is the SWS survey, which has the ratings of 170 and above, that's excellent, et cetera, et cetera. And then for study duration, so Professor Dressel's 1986 to 2022, unfortunately, the data for SWS only started in the last quarter of 1990. So we have to exclude all the data before last quarter of 1990 and then last quarter of 2023. So we ended up with 113 cases and 1,384 observations that involve 71 justices. Okay. So what do we mean by mega political cases? Ito yung very tricky, and this is where Professor Gatmaitan came in. No? So how do we decide if this is a mega political case? So one is, and this is a criteria used by Professor Dressel, so we want to be consistent with what is in the literature already. So it was covered by major news articles. It was cited by articles about the Supreme Court in law publications. They also include the constitutional law syllabi of professors because it means that these cases are very important in the jurisprudence. So assuming the professors are updated on the cases that they teach, then we should be seeing these cases in their syllabi. And then the part of the vetting process was also interviewing constitutional law experts in the UP Law, which includes Professor Gatmaitan. So kaya yan yung trabaho, yan yung contribution niya sa paper na to. Yan. And then so we built the database, as I said, nabanggit ko na pala to. And then the net satisfaction ratings. Just to specifically go through the data in our data set, we looked at we included data on the individual characteristics of the justices. Why? Because we want to see whether individual characteristics also affect the decision of the justices. So basically, this model is a choice modeling. You look at the different factors that influence the choice of justices. So we included the previous job of the justices on whether they came from the judiciary, academia, executive, private sector, or constitutional bodies before assuming the position of a Supreme Court justice. We also looked at their alma mater, where they graduated, where they finished their law degree. So UP Ateneo, UST San Beda, and others. Hindi po ako ng others. Mas konti lang talaga yung frequency ng iba, kaya ako nilamp as others. Okay, and then sex, biologically male or biologically female. Whether the justice was appointed chief justice, kasi gusto kong makita kung may influence ba yung halimbawa feel mo na mag-chief justice ka, do you really always vote in favor of the administration? So you get the position. The length of time the justice has been in the court when the case was, decided, the total length of time the justice served in the Supreme Court, and then dummy variables for the appointing president. And then we also have the case description. Yeah, it's a multi-level logit model. Kasi so you have characteristics for the individual and now characteristics for the case. So we have a dummy variable that analyzes on whether the case favors a current administration. What's an example of a case that favors a current administration? For example, an interpretation of a Bill of Rights. If it's a case that favors the administration, then it means that the interpretation would be narrowing the exercise of individual rights, right? Tumatango si Prof. Dan. So tama ako. So pagka in favor of the administration, that's not favorable to us as citizens. Diba? So that's an example. So we had to code kung yung mga cases na to, is this expanding the government's rights, especially kung may cases naman versus executive legislative, does this one favor the executive more than the legislative? And then we also look at whether the case involves the president that appointed the justices. And then the nature of the case. So these are the mega political cases that we covered. If the case covers separation of powers, executive prerogative, Bill of Rights and individual liberties, elections, economic issues, so yung mga issues ng privatization, especially during Ramos' time, they were included in this data set. And then cases of corruption. And then we have dummy variables representing the administration when the case was decided, a variable indicating whether the case decided was during the early years of the current president's tenure. So to summarize, the scope of our studies from 1990 to 2023, we had 106 mega political cases, 1,384 observations of individual votes of justices, and 71 justices. Okay, so this is a regression model that we used. We did the multi-level mixed effects logistic regression because, as I said, it's a choice model, but it's multi-level because we have the random effect, yung mga variables related to the individual characteristics of justices. Then we have the second level being the characteristics of the cases, and the third level being the public acceptability of the president. So the third level represents the political context, more or less, when the case was decided. And the variables that cover the third level would be the SWS dataset. Okay. So for descriptive statistics, for the justices, interestingly, half of our justices came from the judiciary before being appointed as a justice. But there are individuals who came from the academe. So pwedeng maging justice ang mga nasa law, Justice Leonen came from UP Law, and even from the private sector, and then Constitutional Commission. And then alma mater, actually very interesting. Dapat pala nilagay ko dito na cross tabs. Kasi during the time prior to Duterte, prior to Estrada, majority of the justices came from UP and Ateneo. So when Estrada came in, that's when we had appointments from San Beda, etc. And then Duterte. So nagkaroon na ng variety in terms of the academic profile of the justices in the Supreme Court. Majority of the justices, of course, are male. Average tenure period is 7.5 years. And these are the appointing presidents. So in the 71 justices that we examined, 4 were appointed by Cory, 14 by Fidel Ramos, 6 by Joseph Estrada, 21 by Gloria Macapagal Arroyo, 6 by Pinoy, and then 20 by President Duterte. And then with respect to the cases, these are the distribution, number of cases involving the appointing president when the case was decided. Because sometimes it takes a while for cases to be resolved. So majority of the cases were resolved during the time when it was brought to the Supreme Court. So 86, we had 12% economic cases, 10% election related, 14% Bill of Rights, 35% executive prerogative, 21% separation of powers, and then 5% corruption cases. So with respect to net satisfaction ratings of presidents, these are the average scores. No? So Cory has 37.33. So medyo magkakalapit naman. Ramos is 36. Estrada is 31. Well, GMA is -5. Pinoy is 44. And Duterte is 64. And then with respect to the Supreme Court ratings, lagi naman siyang positive, no, across administration. But it was it has the highest net satisfaction rating during the Duterte administration and the Aquino administration, and lowest during the Arroyo administration. I know, Cory's administration. And then the House of Representatives also, highest during the Duterte administration, and Pinoy, lowest during Cory. Same with the Senate. Okay, so findings. I did not put the regression results anymore, but I will make the paper available so you can download it. But these are the findings. So individual characteristics of the justices are not statistically significant in the voting decisions of the justices. They're likely to vote in favor of cases benefiting or favoring the current administration. Okay? Newly appointed justices are also more likely to vote in favor of cases favoring the current administration. So we see the freshman effect and loyalty effect. But weak lang naman yung statistical significance niya at P less than 0.10. Okay, the longer the tenure of justices, the less likely the justice will vote in favor of cases that favor the administration. So ibig sabihin, nagkakaroon na ng judicial assertiveness the longer they stay in power. Justices appointed by Arroyo and Aquino are less likely to vote in favor of cases favoring the current administration. So meaning, during the time of Aquino and Arroyo, yung mga justices na inappoint nila are mas may lakas ng loob mag-go against the administration in terms of voting. But interestingly also, hindi ko pala nalagay dito. No, justices were more likely to vote no to cases favoring the administration during Ramos's time. So I think Professor Gatmaitan can confirm that during Ramos's time, there are more cases that are decided against the administration. No? They're also likely to vote in favor of the state in cases involving Bill of Rights. So this is good for us. It means that justices are voting to strengthen the Bill of Rights of citizens. The justice is more likely to vote in favor of the state in cases involving executive prerogative. Okay. Justices are also more likely to vote in favor of cases favoring current administration the higher the net satisfaction rating of the House of Representatives. So just looking at the lens of judicial assertiveness, we think that the court is sensitive on the popularity of the different branches of government, but only with respect to the House of Representatives. So when the House of Representatives is popular, the tendency of the court is to decide favorably on cases that involves the administration. And why is that? And we think that one explanation of this is this weaponization, as some experts would call it, of the process of impeachment, because the impeachment of justices start in the House of Representatives. So nandun yung power. Another possible explanation would be the budget. But the question that we have is when you look at the Senate, the relationship is negative. Kapag less popular yung pag less popular yung Senate, the more likely that the justice will vote on the administration. And we don't have an explanation for that. We don't know why we're observing it in the Senate. And then we see that the popularity of the president and the Supreme Court are actually statistically not significant. So meaning the justices are not sensitive to their popularity. They're not sensitive to the popularity of the president, which makes sense because the relationship of the president and the justices, supposedly it has ended when they were appointed by the president already as a justice. And actually, come to think of it, after that, there's actually no more direct relationship between the president, the executive, and the justices. It's actually the House of Representatives that has more direct interaction with the courts because of the budget and the potential for impeachment being initiated by the House of Representatives. So what did we learn? We learned that as much as we want, we're not saying, as much as we want the court to be very effective and to strictly follow the different methodologies that lawyers apply in interpreting cases, in making decisions, they are sensitive and they are influenced by the different political elements in a society. And it's very important for us to be aware of these different factors so that we can establish mechanisms of accountability with respect to how justices make decisions. So to conclude, we know that the court is not immune to politics. We have to strengthen accountability. I think the effort of the Supreme Court now to make it publicly available, the different deliberations on different issues is very important, especially for public awareness and for understanding on how the courts is appreciating the issue. An example of that would be the deliberation on the case of PhilHealth, right? Because it's so public, it's easy for people to more or less anticipate or predict how the court might make a decision on the constitutionality of the PhilHealth case. Another important thing, and this is a continuing conversation especially for experts in law, is how to improve the process of a selection of justices. Right now, you can actually watch the application process and interviews of justices online. But there are other suggestions like Justice Carpio suggesting that the process should also involve the different branches, the Senate and the Congress and the House of Representatives in terms of selecting and appointing justices. Because right now, it really just depends on the president. The Judicial Bar Council, JBC, the Judicial Bar Council would make a short list, would forward it to the president, and the president would choose the justice. So maybe a greater study on how to establish accountability in the selection process can be an entry point to improve their accountability. I think that's my last slide, so we can now open the floor for questions. Thank you. We have a, yeah, may comments si Professor. Ba't ka magka-question?
Given your study, can you predict the way the Supreme Court will dispose of the cases involving the 2024 and 2025 budgets?
Oo nga, pero dapat you should be able to answer it. You should explain the answer. Ang labo, di ba? My opinion will be very biased because I think the House of Representatives is not very popular right now. Okay, so if I'm basing it on the findings of our study that courts can actually make decisions that are not favorable to the administration, especially when the House of Representatives not popular. And if you're going to ask me, I'm going to tell you, it's not popular under the leadership of Congressman Romualdez. Then just based on this study, I should be confident. I can confidently say that the Supreme Court will decide favorably to us, petitioners of the PhilHealth case, and to demand the Department of Finance to return the 60 billion pesos to PhilHealth. Bakit? Yeah. 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 So I'm not biased. It's supported by data. But maybe Professor Dan, you can explain based on your qualitative studies on the behavior of the court, does the data or does the findings really support what you've observed in your qualitative analysis in terms of how courts make decisions and how politics influence previous court decisions? And maybe you can give us specific examples of cases where hindi ako galit. You can give us an example of specific cases where the court did not follow jurisprudence and they're actually influenced by politics.
Okay. Which one?
Labugan.
Okay. There are two things that I have been saying in class that aren't really supported by by this study. One is that the Supreme Court tends to decide in favor of the president almost all the time. In fact, si Duterte has a 100% winning record. He has never lost until his term ended. Which goes to the other point I'm making. Courts of former colonies tend to enforce executive policies. They are not there to check the executive branch. Iba yung orientation natin eh. So if you measure our success as a pupil of, say, the U.S. government, we are never going to pass. Just as a lot of former colonies, well, there are very few exceptions. Taiwan, North Korea, I think, and sorry, South Korea, and I forget the other one, North Korea. Even you know that's wrong, di ba? But most of the time, former colony ka, your tendency is just to vote in favor of the president, and that's not really what we found, no? Because it's about how popular the House of Representatives is. That's the other thing I always tell my students is it's better to be a U.S. citizen before Trump, in the sense that when they decide cases involving the Bill of Rights, they are clearly pro citizen. Most of their cases, tell me yung cases nila yung burning the flag. That's free speech. Can you say fuck the draft in your t-shirt. Of course you can. That's free speech. Pag ginawa mo yun dito, bastos ka eh. You know, you see the difference yung approach nila. But I'm happy to see that in terms of the Bill of Rights, the justices tend to vote against the state. So I'm happy to be wrong about that one. Kasi naman, it's not empirical. Mine is just an observation of the cases that come out.
Are there any questions from the floor?
So did you hear that? Professor Gatmaitan appreciating the econometrics that we do in the School of Economics.
And it's nice to hear the word empirical from a lawyer. Are there any questions? Shelo, can I? Oh, okay, you first.
All right. Good afternoon po, ma'am. Johan Laksamana, BS Management Economics student from UP Baguio actually, just visiting today. Na-mention niyo po kanina na negative po yung, the Supreme Court is less likely to vote in favor of sa Senate po, ma'am, basically. It's inverse. What further studies can be conducted to see yung factors po nun, ma'am?
Maybe expand the cases, longer period, other measures of popularity. Inisip ko kasi kung ano yung possible na hypothesis natin why the relationship is negative. The effect of the trial is not as big as the effect of the initial impeachment in the House of Representatives. But yeah, maybe, but the thing is the data set that we have already include almost all the mega political cases post-EDSA. And it's a natural cut off kasi the context before EDSA is very different. So parang controlled naman na yun. No? So we'll see. Maybe other measures of popularity of the different branches.
Shelo, can I ask one question? So I think this study is awesome in that it tries to look into voting behavior of justices, but I see one potential identification issue, and you mentioned it in your slide, that sometimes you can't distinguish between, say, loyalty and the freshman effect. And definitely the former is more political than the latter. Have you tried any remedies to that? Because that will strengthen your case that, if the former is the one that's dominating than the latter, you can't really distinguish ex ante, because from the time of appointment, for the first few years, it's either the freshman or the loyalty thing that can that can uh, that can happen at the same time. But have you tried, say, looking at cases where there are close votes, like uh, you know, I don't know, like they're deadlock and the justices basically are called by the president. Maybe that's the case now.
Possibly, it will be good to
Mm-mm.
complement it with a focused case study to thresh out the possible explanation on whether it's freshman or loyalty.
Yeah, because if you
Yeah.
can see, say, what, I don't know, since it's a close case, then probably there's no freshman effect because there's no. I mean, you're not going with the herd, right? It's
Actually,
and second, why will the nature of concentrating on mega political cases have an effect? Why not? Why not just the plain vanilla political cases? Not
I will
the megas.
let Professor Gatmaitan answer the second question on why it has to be mega political cases. But on the first one, I think the evidence is stronger on the loyalty effect. Because when you look at the variable naman, that looks at the length of time,
Mhm.
ng tenure of the justices, you can see that the longer they are in power as appointed justices, the more likely that they will vote against the case of the administration. So I think we're seeing that more than the herd effect of the freshman effect. And then maybe another variable that we can include would be examining the newly appointed and whether, because when you say freshman effect, it's not really just voting in favor of the administration, it's voting with the
With the crowd.
majority.
Yeah.
Yeah, with the crowd. So maybe another variable coding that might
That's
be
why I was thinking of
helpful,
maybe
no?
close cases kasi
Yeah.
baka,
You can see,
that
ano.
that will
So that will be
take it.
because I took care of the quantitative, then Professor Dan will take care of specifically looking at the
It's
the
nice to have a
cases.
spouse that you can.
You can so you will do the qualitative.
Oh.
And then you answer why mega political cases and not just all political.
First of all, the president cannot call the justices. Okay. Bawal yun. It makes for great television. And it happens. Nangyari ano sa Lambino when they were trying to amend the constitution. It was close. It was one of those things. And the Ramos, I think it was Ramos, tried to call in favors. I appointed you. And I'm collecting. Pero, you know. No, of course. No. We know.
May bumulong.
Why does it have to be political cases? Kasi we were stressing the importance of the court in establishing the rule of law, di ba? And run-of-the-mill cases do not test that conflict, yung capability of deciding the right way or the wrong way. So we picked those gigantic cases that could send us, could destroy the country. Halimbawa, if I had to think of one now, I'm thinking if the court decides to intervene sa ICC, because there are cases saying na can they issue a TRO against the ICC, yung mga ganung kaso will tell us exactly the role of the court, yung importance ng role ng court, and that is why yes. BP22 bouncing checks law. Political? Appointments, di ba? By nature, valid ba yung appointment? Kasi there's a yes. Yan. So, halimbawa, there's the constitutional provisions on appointments are vague. So yun, they have some leeway on how to interpret that appointment, is it valid or not. But they're not earth-shaking. In fact, yung mga nag-dissent doon just gave up eventually. They said, nobody's voting my side, so never mind, I'm voting with you. Which is also something weird. Di ba? Kung mag-dissent ka all the way. So that's what I mean by it's political, but it's really not earth-shaking. But when you start talking about PDAF, is that constitutional? It has serious implications on how we run government, and those are the cases in our data set. Okay, yung mga ganung klaseng impeachment, di ba? Yeah.
Expand the definition of how the jurisprudence is interpreted.
But there are existing definitions. The first one, I think, to actually define it is Herschel. Those that go beyond issues of procedural justice and political salience to include, quote, core political controversies that define and often divide whole polities. And that's where we are now, di ba? In terms of Duterte and the ICC. Yung mga ganun, mga extremely divisive cases.
So in relation to that question, there's actually a previous study by Descriptive and Descriptive. So also lawyer and sister lawyer and economist. I think they actually looked at run-of-the-mill cases and looked at similar like loyalty and also what do you call that? Strategic defection. But they looked at run-of-the-mill cases, meaning they randomly picked cases, and there was no substantial difference. And I think that's why, in effect, and also based on, I used to work in the judiciary in the Supreme Court, and in most cases that we actually worked on, there aren't even dissents. Justices are like, okay, I agree, and I think it's in these cases, these mega political cases, where you actually see possible policy preferences, possible loyalties coming out because they're so high stakes. So maybe that's why it's also a better idea to just focus on these cases.
Actually, our court is a very interesting court to study because in the US, sometimes it's predictable because they identify as Democrats or Republicans. So more or less, you can predict where they stand on big issues like reproductive health or abortion or divorce, etc. But in the Philippines, we don't have that. It's so hard to profile the justices. When you're looking at the individual profiles in the US, you can tag them, diba, on their political affiliation. In the Philippines, the individual characteristics that you can use is just their affiliation, their academic affiliation. We wanted to include their political network, like the fraternities that they belong to, but it's so hard to find the information related to that. But I think that's a good study, mapping the political network of the justices and how they make decisions also. But an index can be developed, but it's hard.
In Zoom. Okay. Okay, there are many questions, but let's start with Dr. Corina Bautista. What is the dependent variable?
So it's a logistic regression. So it's a yes or no on whether the justice voted in favor or not of this case. But to make sure that a vote in favor of a case doesn't necessarily mean that it's a vote for administration. So we have another variable that tagged on whether the vote was for administration or not. So we did a lot of interaction when looking at the different coefficients.
Okay, Mr. Ray Navarro, can we see the conceptual framework?
Yeah, we'll make the paper available to the public so you can read it.
Mr. Duque, how does the Supreme Court's ruling in the Farmally case illustrate judicial assertiveness in checking legislative powers and safeguarding due process rights?
By the way, what case are we referring to? No? Is it the challenge to the jurisdiction of the, I simplify it. Is it about arresting the formally officials? Kasi kung yun, then it's the opposite of judicial assertiveness because the court invented objections so that they didn't have to handle the legal issue. Yun ang ginawa yun eh. Dalawa yun eh, but I cannot remember the other one. But in other words, the court said we cannot decide this issue because there's a jurisdictional challenge. There's a question is whether it's the Senate that can handle this issue or that body created under the ano yung mga batas natin nung ano? Tugilas 1, Bayanihan, under the Bayanihan laws. And I say that's the opposite of judicial assertiveness because there is no objection. I don't know where the heck the Supreme Court came up with that argument. So if those are the cases that the question is referring to, then there is no assertiveness.
I have to answer the next one. It's about the
Rule of judicial activism.
So the administration's government must be participated in the Supreme Court. When you say that the case is favorable to an administration?
No, it's just the position taken by the administration. Diba? Halimbawa, okay, it's a US case, but I love it. Okay. Halimbawa, there's this girl, high school, I think, she applied for the cheering squad of her school and didn't make it. Okay. And then she goes home or somewhere and starts ranting on Snapchat. Remember Snapchat? Ranting, using bad words. And she got dismissed from the school. And the Supreme Court said you can't do that because that's free speech. That's what I mean. The state taking a position that is against the rights provided for us as a Bill of Rights. Or in that case, the school.
Decision favoring a student is a decision that is against
The state. The admin. But broadly speaking naman.
yes, where does a good administration stand on those cases?
Ill-gotten wealth should be for the recovery of the wealth. Ang position ng state. But that's not a Bill of Rights case. Or Hacienda Luisita, for instance, if you're trying to distribute the land, then that's the government's position. But again,
We have to, in tagging on whether a case is favorable or not to the administration, we have to look at what the government is actually arguing in the case.
Explicitly, maybe baka sasabihin nila wala kaming posisyon dyan. But
no. All these cases, they
okay.
involve the state. Halimbawa, are these included in the study? No, di ba? Because we're talking about the quo warranto case against the Chief Justice. Ang position ng state doon is she can be removed through means other than by impeachment. Di ba? Which everybody believed was not possible until the decision of the court came out, siding with the government. Naiintindihan yung frustration namin doon. Pag tinanong kami ngayon, how will the court decide this? Technically, bawal na. But before the new rules of conduct came out, pag tinanong kami, we would have said, that's easy. You cannot do that because a whole bunch of cases say this. And also, the court will come up with a really, weird decision. We're not sure anymore. So when you answer a question, you go, this is how they used to answer it. But let's see how they were going to do it today.
Yeah, I mentioned kanina one landmark case, which is Labugal, which is a favorite case because imagine a situation when you have the same Supreme Court, different decisions after 6 months. And when the Labugal case is a question of the constitutionality of the 1995 Mining Act, where they actually allowed 100% foreign ownership. In the first decision, they decided that the law is unconstitutional. And then what happened? And then after 6 months, the same court, no new appointment,
reversed.
same composition, reversed that decision. You know what happened between the first decision and the second decision? There was an election and GMA was re-elected again. And when she was re-elected, one of the economic pillars that she was advocating is the entry of foreign ownership, foreign investment through mining. So interestingly, now that she has a fresh mandate, the Supreme Court, without a change in composition, changed the interpretation of the Constitution.
So what's the lesson there? When you win, you celebrate because you don't know how long it will last. Actually, and here's a good example. Kasi normally, if you try to figure out what the Constitution means, you can look at the records of the CONCOM. And then first decision where it was unconstitutional, the justices read those parts of the record that proved it was unconstitutional. Hindi pwedeng 100% ownership. And when they reversed it a few months later, they read other parts of the record of the CONCOM that seemed to say it's okay to own 100%. Foreign ownership is allowed. And that also goes to the question of, why mega political cases? Diba? Kasi you can go either way and has very serious implications on resource ownership, environment, etc., etc. But in our cases, kasi, the side of the government is clear, diba? Yeah.
So you focus on those cases that the government has a stated position.
Bill of Rights. So it's either you expand the rights of citizens or not. So when you reduce the rights of citizens, that's in favor of the government. Executive legislative prerogative, separation of power, then we interpret it in favor of the executive kasi we're looking at the president, no? And then the executive legislative prerogative.
It depends on, diba? Halimbawa sa congressional inquiries, can they refuse to attend? Yan, mga ganyang question. And the standards kasi of the court will be broad strokes, di ba? It depends on the information being sought by Congress. Tapos, they will look at it on a case-to-case basis and they will say, this is beyond privilege. Privilege yung they don't have to disclose. Then the court, in the end, makes a decision. Does this fall within the president's privilege? Can they keep it from the rest of us? Can they keep quiet about it? So, but it will tell you, because there are broad outlines only, the politics that can come in.
Maybe the next question of Ma'am Gochoco, I will defer to the lawyers because she's suggesting that we create an index assessing the quality of the SC decisions. Attorney Bonoan, since you worked in the Supreme Court.
I would find this very difficult. For one thing, like how do you assess quality unless you have like 10 dangats or dangat, tete, all other like retired Justice Bibi Mendoza, and they all side this way. And we actually thought about doing this before. For example, one particular issue, if some of the foremost legal minds all think this way, and the Supreme Court thinks another way, or that's like a benchmark on how you might measure the quality of the Supreme Court. However, it's very difficult to say just by flip-flopping, for example, that I mean, it could be that they were wrong previously, and this is why decisions are overturned. I mean, you had cases in the U.S. Board of Education, separate but equal used to be the rule, and then you realize no, segregation is not a good rule, even though it has already been upheld in past decisions. So I'm not sure that this can be done on a wide scale unless it's per issue based, maybe. Like you're looking at issue of, I don't know, in particular budget. I don't know. So how has the
You're right. Sometimes we want the court to flip-flop, to completely reverse their decision. Because, for example, there are court decisions where they say that it's okay if education is not a budget priority, and yet we continue to bring cases before the Supreme Court for the court to change its previous decision and interpret it a certain way. A decision to not intervene in cases regarding political dynasty. The court said it's up to the legislature, but we still continue to bring it up there because we want the judiciary to change its mind and find a different interpretation on how to operationalize that provision. So it's very difficult.
Mr. Sala's question. That's a lawyer question. So
Among other things. But I don't think that's the way that may was supposed to be construed. I think may there, if you only means that justice may be removed, but it doesn't mean, well, you didn't say shall. So the court said may means there are other ways when it can be done. But again, notice decision removing Sereno is not unanimous. In other words, while the majority said, well, you said may, that means we can remove the president through other means, like a quo warranto petition. The fact is, the other justices said, no, that's not what the word may means. So that's why these are mega political, because this one has implications on the independence of your judiciary. If you allow justices to be removed by ways other than impeachment, everyone is vulnerable now. You can be removed at any time without an impeachment, which to us was not the way the framers designed the Constitution. And in fact, they tried it kay Leonen. Diba?
maybe you can test that, right? Was there a point in time where that threat of impeachment or removal was weaponized before Sereno?
Well, the problem with the other
Meron na? Corona.
the word got thrown around early on. So I need a scientific way of determining when it happened, because every time there's an impeachment, it's been weaponized.
Mhm.
I mean, it's said as a political statement rather than an analysis of,
The question there is, after that, say that cutoff point where it became more weaponized, did the justices side with the president or whatever, or closely House of Representatives?
in the case,
Yeah.
There's a higher like favoring the president.
I think that's an effect of a chilling effect on the Supreme Court. When Corona was removed, removed, no, by the Senate. Before that, No. The ano to? The Supreme Court during Corona's impeachment and trial were decided at least 3 cases that helped his defense. And then when he was removed, the Supreme Court justice, if you interview them, they would say, "We'll do whatever the Supreme Court, the other branches say." Hindi na sila as tough as before. And then that's the effect.
Maybe that's a good way of. Are there any questions in the floor? Ma'am Aleli, were you raising your hand? Ah, wala. Gumalaw lang pala yung kamay niyo. Oh, there's one more.
Ano being assertive? Hindi, because there's a definition of assertiveness eh. Di ba? Which was,
The definition of assertiveness is a tendency or the power of the judiciary to go against key political actors. So, kaya when you say assertiveness, they have that ability to vote against the administration. And that the study is why the assumption is that the judiciary is sensitive to how different actors would react also to their decisions. So because of their sensitivity, then a popular government would likely have an effect on how they will handle the case. So imagine a scenario now when BBM is so popular and the Congress is so popular, then we can already predict how they will make a decision on the 60 billion peso PhilHealth Fund, right? But so it's something like that, yung assertiveness, that because of the sensitivity of the court and judicial politics, there's room in terms of how it's not easy to predict how they're gonna make a decision on the case. And one predictor that we're saying is how people perceive the other branches of government.
Professor Alburo.
I was wondering what is the feedback to your study of Supreme Court justices who have retired but actually continue to write either as a regular columnist or occasional columnist, gives an opinion regarding specific cases. How is that built in? Because when Supreme Court justices retire, they don't retire and end their life. They continue to talk. So I'm asking whether there is a feedback for that.
it's a lot worse than that. Because sometimes a retired justice can represent one of the litigants before the Supreme Court. In mining, si Florentino Feliciano, right? And when you have someone as dignified as Feliciano, never mind sino yung namatay? Mendoza, never mind Mendoza. Kasi that's politics eh. But Florentino Feliciano is spotless as a jurist. And then he shows up defending the mining companies. And then the Chief Justice admits later on, yeah, we bent a few rules to favor the mining companies. Is it because it was Justice Feliciano? There should be a rule actually. There should be a rule that prevents them from practicing after retiring. Kasi the impact is incalculable as of now.
Yeah, but does that affect the assertiveness, for example?
That one we haven't studied. But that would be interesting.
Yeah.
But the problem, sir, is there will be very few cases that involve former justices. But now there will be a few, so we can see whether.
But there are also cases which are a matter of interpretation, for example, of the Constitution. What is the effect of that? Assertiveness. Can I just
That would be the next paper of Professor Gilman.
Yeah, can I just give an illustration of this? Sometime in 2019, President Duterte made a statement, public statement, that that those who claim that the Constitution gives exclusive rights to Filipinos to exploit resources are stupid. and do not understand. So when that was published by the newspaper that this is what President Duterte said, one would have thought that either the Supreme Court or previous justices would have an interpretation of that one. But actually, the more visible former Supreme Court Chief Justice, who is a columnist, did not make any statement at all. And it was only Tony Carpio who made a statement later on defending the Constitution. And President Duterte said he's stupid. Of course, I think Justice Panganiban did not want to be called stupid. So what did he write when the Duterte said? Well, you know what he wrote? He reminisced being president of the Rotary Club of Manila.
I think that's not just judicial politics. I think that's the chilling effect of Duterte's approach to politics. And
Yeah.
it did not only affect the justices, but I think that's an indication of how effective, how bad the chilling effect was, because they were already justices and even they were not vocal enough to correct the policy statements of Duterte.
The court cannot make a statement if there is no case. Okay, so if you cannot wait and say, well, the Supreme Court's not saying anything, they're not supposed to say anything. Okay, yeah, the rest of us can say whatever we want to say and then be called stupid. But see, Duterte doesn't understand how the Constitution works. Every time he opens his mouth, unconstitutional things come out. Okay, like almost 100% of the time. I think he only said one thing that was constitutional. Anyways, the other thing about about justices, and hindi lang justices yung mga influential people I mentioned, si Estelito Mendoza. When Estelito Mendoza, they call him the lawyer of last resort. If you get him, that means guilty ka. You just need help. When he enters the Supreme Court, the justices stand out. Diyan siya ka-influential. And kasi a lot of them were trained by Estelito Mendoza. Mendoza is not a justice. He can write to the Supreme Court if he wants a case reopened. Just by sending a letter. Kaya if you look at the reactions to his death, it's mixed, di ba? Because he's supposed to be one of the best lawyers, I don't know about that, of all time. And he did all these other shady techniques. So meron tayong mga ganyang problems.
Can I just finish my statement? When I read that, and he didn't say anything at all, and it was Tony Carpio who made the defense in the Constitution. I wrote the Daily Inquirer about it. They never published it. By letter.
Mama Lely, do you have a question?
Thank you. Kasi there's, hindi naman implicit, but maybe your emphasis on whether it's in favor of the government or not. Parang may, hindi ko alam kung presumption yun or it's just my interpretation that the government's position might not be correct from some particular viewpoint. Maybe but we cannot say that always. It might be, I'm not sure, that sometimes the government position might be the correct one. We don't know, right? So it's probably just putting a limitation kasi it might be that yung when we say that you're not in favor of the government, can be presumed that, that is not correct. But what your paper is just saying is that there's that siding with the government position without any saying that the government position is supposed to be right or wrong. And that's really slippery slope. Parang lang, qualification, so that it's not like, because we don't really know, right? And in fact, parang it's really subject to interpretation because it's the Supreme Court decide. Parang, you know, that's just parang maybe a limitation or a qualification that can be put. I know we have our own perceptions or we have our own opinions about whether that is right or wrong, but we don't really know. No, so parang ganun lang yung some caution maybe, no, because unless there's another arbiter, we cannot really say, no. But the way it's presented, yung like more likely ganyan, okay naman, kaya lang maybe we need to have some okay.
I will say kung mali yung Supreme Court. Mali siya because that's not what the framers said. Mali siya because that's not what you said before. Mali siya because it goes against recognized principles of, you know, civil liberties. And I don't have a problem with that. Although I understand what you're saying. Pero kung ako lang, I'm not, ba? I didn't get a reputation by being quiet. And I have one.
Are there any JC? And after JC,
Hello, thank you, Shelo and Sir Dan for the presentation. I have a question about the use of survey data on, ratings concerning the Supreme Court. Number one, I'm not familiar with how it looks actually over time. If there's enough of a variation over time that we can actually speak of as a source of exogenous change that can drive judicial assertiveness. And then more fundamentally, I'm just wondering about about how much information we can actually extract from survey data on ratings of the Supreme Court. I mean, for the ordinary people, alam ba nila actually ano may Supreme Court in the first place to form an opinion about it, whether they trust it or give a favorable opinion of it. So ayun, kasi parang if you compare that to the ratings of a president, for example, or a vice president, parang is a more concrete office or a person or official. Pero for the Supreme Court as an institution as a whole, I'm not too sure if people actually know what's going on or what it is all about in the first place. So any thoughts about it?
I agree with that, but unfortunately, we don't have a lot of data that we can use in terms of evaluating the political trust of the different offices. And I agree also on the observation of the Supreme Court, and that's probably the reason why we see we don't see a lot of variation in terms of how people score the Supreme Court, and that's probably the reason why it's statistically not significant. I actually wonder whether there are other indicators that the Supreme Court might use in terms of how it perceives itself. Maybe with another indicator can be done, another study. Maybe I've seen this in other studies, like for example, mentions in newspapers, qualitative studies in terms of how popular, whether these reports are negative or positive, can be developed into an index. But that will be for another study when Professor Gatmaitan does his PhD. Dissertation.
Professor, that meron bang parang ganun din, trust ratings or ano, confined to academics or lawyers, not the public? Na parang, I mean, like academics, we say na medyo banutong ano, but yung banu, that's such a 90s ano, term.
70s
Like
pa
that.
yan.
Decision.
Oh, no. Not systematic.
Yes. Can you imagine the lawyers criticizing the court and really telling the court that their decision is wrong? Or some no. Some would actually
No, we can just get Professor Gatmaitan's rating.
when we do a peer reviewing of people's articles, you can really say their article is stupid, etc.
So there's nothing exists like in the profession that you can, legal profession, even in academic settings where you say that, the Supreme Court is doing well because it's consistent with with principles that it's supposed to uphold.
Making an assessment per case.
Kasi 'di ba, economists can criticize like the economic management of a president. Can lawyers criticize the voting patterns or the decisions of the Supreme Court?
Hindi siya, di ba? That's what law reviews are for, di ba?
But it's not a lot of lawyers do that.
Yeah, oh yeah. But sa US talaga, it's like every time there's a new case, it's a flood of new articles.
Yeah.
Political maturity. Legal professional.
Sir, can you?
That those are in the Supreme Court and the courts will act on the letter is an indication of how informal the system is, diba? And if the system is that informal, then you have to fear that you have to worry about the implication of what to say about it. Diba?
My question is, does like the Chief Justice have like influence on like how the court decides of whether it will decide pro administration or anti-administration? I'm getting this sense from like, I mean, this is like US for me. I got this sense from like the US, like for example, the Marshall Court or the Warren Court, where they're more progressive when, you know, Earl Warren was the Chief Justice. Is the Philippines also like that or
No.
No.
But you may be overstating the US case. What's the one you mentioned before, Warren?
John Marshall,
John
like
Marshall,
Chief Justice John Marshall.
His concern was more, well, he did try to influence others so they could have a more unanimous decision. Because personally, he thought a divided opinion had less impact on the public. So meron siyang campaign. Pero it wasn't, I'm not sure I read na it was policy or how many cases actually became unanimous because of his efforts. Si Warren, who is my favorite justice of all time, was a conservative appointee, di ba? And then he became more liberal than any of the justices ever. Itong si Warren is the one responsible for the Miranda warnings. See? It amazes me how we know what to say when we're being arrested. What the police will say when we're being arrested. Yun yung Miranda warnings. Among other things. No? Pero they don't, I mean they will try to, kasi nagde-deliberate sila eh. Diba? So they will try to agree on the issues. And iba-ibang process yan eh. So let's say the ponente has finished, the writer of the opinion has finished, the draft will be circulated so that you can agree or disagree. And if you want to write a dissenting opinion, you can do that. So yun ang ginagawa nila. It's not na walang whip, walang command vote.
So, sir, in the Philippines, like the Chief Justice is not really that influential.
Yeah, it's more of yeah. Kaya nga the first among equals. He doesn't have any more powers. He has more responsibilities. It's a thankless job. It's a thankless job. Ikaw lagi yung magsi-speech, you know, but your vote is not weightier than the vote of the other justices. Pare-pareho lang kayo.
I'm just wondering whether you can, I'm sure you can because you have the data, whether you would have information on the likelihood of them dissenting against, let's say, a position that favors the government. Parang, di ba, because these are individual votes eh. You said these are individual votes. And so you can have like, it will be interesting to see if the majority voted in favor of, let's say, the government or whoever, no, whether they did dissent. The likelihood of dissent, parang in a way, well, it's another study.
Okay, so we have, unless there are questions, we can continue this informally. Okay, so we know that judging from the reactions of both the Zoom audience and people here, that the marriage of law and economics is really exciting. And we have here a couple who did that literally. Okay, so thank you so much, Professor Shalomagno, Professor Dan Gatmaitan. Very exciting paper, and we hope that we see more of these types of studies too. Thank you. Thank you everyone for attending my evaluation form again, so that our food can be liquidated. Okay, and thank you so much for attending. We hope to see you in the next final two for this semester. The next week, hopefully, will be by Dr. Noel de Dios, and the last week would be by former national statistician Lisa Bersales. Okay, thank you so much. Ang ganda, pero alam mo kung para pwede ang ganito, multiple channel. So like YouTube, Facebook, and ayun tayo ni Boss Ben yan. By the way, have some merienda. Ang ganda, oo, tama. Pero ano mo magandang extension yan? To distinguish lang yung freshman from the